Can a violent assault be punished without proving an intention to kill? Also, does a patient's death automatically amount to criminal negligence by a doctor? And can an industry claim a government benefit that was never meant for it? Here are the top judicial developments of this week. On 22nd May 2026, in the case of Roshan Lal versus State of Haryana, the Supreme Court reduced the conviction of 3 accused from Section 307 IPC attempt to murder to Section 325 IPC grievous hurt in a 2000 Haryana assault case. The court observed that although the victims suffered serious head injuries, there was no intention to kill, no prior planning, and the assault occurred suddenly during an altercation. The accused was sentenced to the jail period already undergone along with the fine of Rs 50,000 each payable to the victim. On 25th May 2026, in the case of Supriya Kumari M.C. versus State of Kerala, the Supreme Court quashed criminal proceedings against a senior anaesthetist accused in a 2002 medical negligence case involving the death of a patient after a surgery in Kerala. The court held that merely advising medication over phone while being off duty does not amount to gross criminal negligence and found contradictions in the statements of witnesses. Relying on Jacob Mathew versus State of Punjab, the court reiterated that criminal liability against doctors arises only in cases of extreme serious negligence. In another case of 25th May 2026, State of Himachal Pradesh and others versus Mrs. Kundla's Loh Udyog, the Supreme Court held that promissory estoppel cannot be used to claim a government benefit that was never intended for a particular category of beneficiaries. The court ruled that concessional electricity tariff benefits under the Industry Policy 2019 was meant for new industries and not for existing units undergoing expansion, and therefore allowed the state's appeal. And that's all for this week's judicial updates. Stay tuned with Law Time for more such legal updates. Thank you.